Hi, my name is Jason Asbell. I'm an attorney at Gibble, Crable & Hess. In this video, I'm going to talk with you about disciplinary actions at colleges and universities. For simplicity, this presentation is focused on student discipline, but much of what I'm about to discuss also applies to the discipline of faculty and staff. College disciplinary actions can cover a broad range of conduct, including academic offenses, honor code violations, alcohol and drug possession, and physical misconduct. The penalties can range from a warning to permanent notations on a student's academic record and suspension or expulsion. It's important for colleges to take seriously and investigate potential misconduct and to impose the appropriate punishment. However, from a student's perspective, it is also important to know that an accusation does not mean guilt and that the outcome of a proceeding can have a significant impact on your future. Each college has its own disciplinary code and procedure, which is usually found in the student handbook. For example, your college may use its own definitions for certain terms, what constitutes plagiarism and what is harassment. Your college may also set out unique procedures for investigating and making a determination of misconduct, which also might vary depending on the type of misconduct. Specifically, allegations of sexual misconduct will often have different procedures from other violations. It's very important to study your school's disciplinary handbook in order to know your rights. Usually, there will be a college administrator who is designated to investigate an allegation of misconduct. The administrator will likely reach out to the accused student to get the student's side of the story. This step is particularly dangerous for students who are accused of misconduct that is also a potential criminal offense, like harassment or assault. The local police can likely obtain the student's statement from the college, meaning that the student's statement could be used as evidence both at the college proceeding and in a later criminal proceeding. If the college investigates and believes that a violation occurred, the college should notify the student in writing of the specific charge against him. This letter should also inform the student of his rights moving forward, and the right to have it, such as the right to have a hearing or to have an advisor. The college will usually then hold a hearing. A college disciplinary hearing does not follow the same rules or offer the same protections as a trial in court. Sometimes the hearings are informal, like where the student meets one-on-one with a hearing officer. Often, for serious offenses, or offenses where the student disagrees with the hearing officer's decision, the student can request a formal hearing in front of a committee. That committee might be made up of students, faculty, and administrators, and the student is able to call witnesses and present evidence to the committee. Unlike a criminal case in court, though, many colleges attempt to limit the student's ability to meaningfully cross-examine witnesses who are testifying against them. Many colleges also limit the student's ability to have an attorney at the hearing. For example, the school might allow an attorney to be present, but then limit the attorney's ability to actually communicate to the committee. Similar to the investigation stage, any statements that the student makes at the hearing could be used against them later in a criminal proceeding. The decision of the hearing officer or committee and any punishment that they impose should be set forth in writing and provided to the student. The student handbook should describe the level of evidence that is needed to find that a student committed a violation. The standard is often a preponderance of the evidence standard, meaning that it is more likely than not that a student is responsible for the misconduct. This is a lower standard of proof than what is available in a criminal case, where the guilt of the accused must be proven beyond a reasonable doubt. After a decision and penalty is rendered, the college should also have an internal process for the student to appeal. In addition to utilizing the college's disciplinary procedures, it may be possible to challenge the college's actions in court. For example, there might be a legal claim if the college failed to follow its own policies and procedures or did not give the student a fair opportunity to defend himself. Consulting with an attorney at the earliest opportunity is vital to protecting a student's rights, especially if later criminal charges are possible. We at Gibble, Crable & Hess have the experience defending both students and faculty involved in disciplinary proceedings. I hope this information has been helpful, and thank you for your time.